Hello, and welcome to Ask an Atheist. My name is Rebecca Markert, and I'm the legal director here at the Freedom from Religion Foundation. Today, I've asked two of my fellow FFRF attorneys to come and discuss the biggest news from the Supreme Court this last week, the decision in the case Fulton versus City of Philadelphia. I'll let them introduce themselves.
Hi, I'm Sam Grover. I'm Associate Counsel here at FFRF and a member of our litigation team.
And I am Andrew Seidel, the Director of Strategic Response at the Freedom from Religion Foundation. As always, if you have questions about our topic today, you can drop them in the comments below or send an email to askanatheist@ffrf.org. And I'm sure you're going to have a few questions today.
So June is a big month for the Supreme Court. We're nearing the end of their term, and so there's always a rush of big opinions that are handed down before June 30th. That's the traditional end of their term. And just this morning, in fact, there was another First Amendment case that was decided involving a cheerleader and her free speech rights. The court ruled in her favor 8-1, and we are currently reviewing that opinion and evaluating what its impact will be on our work as well. But back to the theme of our day, we've been waiting for the Fulton decision to come down all year. It was argued the day after the election last November, and we've mentioned on the show many times that we were waiting for this decision. But even though we've talked about it ad nauseum on this show, my question first is always, explain the case. So I'm going to ask Andrew, can you remind us what this case was about and why FFRF was concerned enough to submit an amicus brief in it?
Sure. So the government has a duty to care for children who live in otherwise dangerous circumstances. For Philadelphia, they have about 6,000 foster children, and the goal is to care for or place them in foster homes if possible. And Philadelphia wanted to do that without discriminating against citizens. The Philadelphia Fair Practices Ordinance ensured that the widest possible pool of people would help these children by prohibiting discrimination along lines of color, race, religion, gender identity, or sexual orientation. And this is actually especially important when we're talking about LGBTQ youth, because there's a high number of homeless LGBTQ youth who are in need of help. And they might feel more comfortable and loved, frankly, in a home that, for instance, some people might not consider traditional or Christian. And back when this started that year, the city was actually pushing a recruitment drive, trying to get more foster families, and especially for at-risk youth, including those LGBTQ youth. Catholic Social Services had no such scruples about discrimination, believing instead that discrimination was required by their God. And that's kind of what led to this collision, because Philadelphia contracts out many of the administrative duties of the foster care system, including vetting families. So interviewing and screening and training and even certifying families that might foster those children. So in 2017, 2018, the city contracted with, I think, 30 different groups to provide that vetting. All of them had identical contracts. And Catholic Social Services was one of the groups that the city contracted with. So it was taking care of this vetting, and it was doing some other duties as well, including operating group facilities and managing many of the other cases. But that vetting is what caused the case to go to the Supreme Court, not actually placing children with families, which is, I think, a really important distinction and something that's been missed by some media covering this. So the Catholic Social Services full name is actually Catholic Social Services of the Archdiocese of Philadelphia. So it is an extension of the Catholic Church, and this is the same church that has abused children for centuries, and which was the focus of a massive grand jury report in this same state. The grand jury report that came out a couple years ago didn't actually include the Archdiocese of Philadelphia because that was subject of two previous reports on its own. Anyway, in March of 2018, Catholic Social Services explained to the city that it was not going to vet families or people that didn't meet certain religious criteria. Specifically, it wasn't going to certify same-sex couples as prospective foster parents, even if those couples were eligible otherwise under the state regulations. And it said that it wouldn't conduct home studies with those same-sex couples as part of their adoption. So, I mean, to put this more simply, Catholic Social Services refused to do the job that it was contracted and paid to do. So the city of Philadelphia said, okay, well, we have this ordinance in place and you're not willing to do the job, so we're not going to let you do that job. You're not going to vet anyone. And the city still actually worked with Catholic Social Services on other aspects of the foster care, just not in those areas in which it discriminated. So that's kind of the setup of the case. And Catholic Social Services challenged that sort of suspension of their contract in those areas. And that's what worked its way all the way to the Supreme Court on religious freedom grounds.
And we've been really worried about how the court was going to rule in this case. We all are aware of the trends that the court has had on religious liberty cases. They have not been good. Religious liberty is of increased interest to the court and is an area of law where the court has moved the needle the most. Yes. That's away from state-church separation to increased privilege to religion and really privilege to Christians. And our regular viewers know that we've been watching many cases over the last year. There were 3 cases last summer that didn't turn out well for our cause, especially with respect to government funding of religion and ministerial exemptions. And this past winter, while we were all enduring the pandemic, we saw the court make similar moves in the wrong direction in the so-called shadow docket with respect to some of the cases involving challenges to COVID restrictions in different states. So in a sense, it felt like we were all conditioned to really be awaiting a decision that was going to be very, very bad. And when it came down, the first thing we saw that it was 9-0 in favor of the church, and really thought this is our moment. This is going to be epic. It's going to be incredibly disheartening, and it's going to be the dagger for religious liberty as we know it. Yeah. But that's not exactly what happened, did it?
Right.
So can you explain what was going on in that case? What did the majority hold?
Yeah, so I can talk a little bit about the majority opinion here, which was written by Chief Justice Roberts. I'll start with the holding, basically the punchline here. So Philadelphia's requirement that foster care agencies not discriminate against gay couples if they want to contract with the city, that violates the free exercise rights of Catholic social services. That's the holding here. And to reach this backwards conclusion, the court had to start where legal analysis should start. It had to start with precedent. So in the Employment Division v. Smith case, that sets the standard of review here. And the rule is that neutral, generally applicable laws that incidentally burden religion are okay. It's not a free exercise violation if you have a law that's generally applicable and it's not targeted at religion. And what the Roberts decision does first is it says, okay, well, there's an exemption, a potential exemption in this non-discrimination rule where the commissioner, the city commissioner, can exempt someone for any reason. There's complete discretion for the commissioner to exempt someone, and even though the city has never exempted someone and doesn't intend to exempt anyone, that makes this not a generally applicable non-discrimination rule. So instead of being under Employment Division v. Smith and its sort of rational basis review, instead this rule is in the world of this other case where strict scrutiny is applied. The case is Lukumi. This non-discrimination ordinance has no similarity at all with the facts of the Lukumi case, basically in that the city of Hialeah was up in arms about the idea that a Santeria Church was going to be operating in the city, and so they passed a targeted law against animal slaughter and animal sacrifice, which is how the Santeria Church was worshiping. And there are all sorts of exemptions for things like, slaughterhouses and that sort of thing. And so it was really just a targeted rule to keep the Santeria Church out of the city. And that law received strict scrutiny review, which is basically unless the government has a compelling interest and the law is narrowly tailored to achieve that interest, it's unconstitutional. So the Roberts decision says we're under strict scrutiny review here with this non-discrimination ordinance, even though this is nothing like Lukumi. And even then, the Roberts Court did another unusual thing. So instead of asking whether Philadelphia had a compelling interest in avoiding discrimination in its foster care program, instead the court asked whether the city had a compelling interest in denying an exemption to that rule to Catholic social services. And that narrow framing has never been how this strict scrutiny test is applied. And it sounds an additional alarm for practitioners of First Amendment law like us.
Right. And the majority opinion is actually very short. It's only about 20 pages long.
Yeah.
But there are several concurrences, one of which is over 70 pages, Justice Alito. And in a sense, Justice Alito's concurring opinion, reads like it could have been a majority opinion if they had garnered the votes. Can you talk a little bit about Alito's decision?
Yeah, I'd be happy to. Like you said, it's a long decision. I guess first it's worth mentioning for maybe some people who aren't really versed in the law. So this is a 9-0 decision. The Roberts opinion, it's 9-0 basically on the result of the case, that Catholic Social Services wins, the city of Philadelphia loses. But the reasoning in reaching that result is not 9-0. There are some justices who are more evil than others and wanted to join Alito's separate decision to really establish firmly that they are super evil. So that's Alito joined by Thomas and Gorsuch, who wanted to establish that they would go even further and use this case as the vehicle to overturn Employment Division v. Smith entirely, so that is never how you evaluate neutral, generally applicable laws. So Alito's decision, it starts by lamenting that the Supreme Court was unwilling to use this case to overturn Smith in its entirety. And instead, and so Alito writes, this decision might as well be written on the dissolving paper sold in magic shops, which is about as pithy a phrase as he'll ever write in a decision. He's not a good writer. In his decision, he conjures up a bunch of hypothetical scenarios in order to demonstrate that Smith should be overturned.
The parade of horribles.
Yes, the parade of horribles. And none of these hypotheticals are put religious freedoms at odds with basic civil rights, the way the actual case before them does. And none of these hypotheticals have actually happened, right? That he brings up he conjures up these hypotheticals despite Employment Division v. Smith having come out in 1990. So this decision's been around for a long time.
And was written by Justice Scalia.
Right, yeah. Right, the Smith decision is not like some ultra-liberal decision. It's penned by Scalia. It stakes out a very rational test for how to ensure that the government can actually function, right? It says, if the government has come up with a general rule, it's neutral towards religion and it's generally applicable, then everyone's got to follow it, even if their religion says otherwise. All right, at any rate, Alito's concurrence is most notable for the reason you pointed out, which is it's 70 pages long and it's written as if it was meant to be the majority decision. So in essence, what this opinion's doing is it's previewing what the next case probably will decide, which is that Smith is overturned. That's what we fear, and I'm sure we'll get a little more into the implications for what the government might look like in that world.
And we've
known...
I think... Oh, I'm sorry. Go ahead.
I just think in a way that Alito's opinion is almost the most interesting, because I think you're right, Rebecca. It really does read like this was the majority opinion, and then there was something happening behind the scenes, some sort of horse trading going on that allowed Chief Justice Roberts to bring on the liberals on the court onto his opinion, make this a unanimous decision in the result, though divided in the rationale, because there are the votes for overturning the Smith case on the court. I mean, in a way, they've already done this in the last COVID decision, Tandon versus Newsom, which was one of the shadow dockets decisions that Rebecca mentioned. And I mean, Alito's opinion is exhausting to read. It's 77 pages. It's 81 footnotes. I mean, it reads like a majority opinion and then you have Roberts's more concise opinion that is frankly sloppy for him, and full of logical holes that I agree with. This feels dirty. I mean, I agree with Justice Gorsuch's criticisms of Roberts's majority opinion there. Anyway, I mean, I think that makes Alito's opinion the most interesting, not because of how it's written. Sam's right; he's a terrible writer. He's not a high-minded jurist, and the fact that he spent so much time on this suggests to me that there's something going on here behind the scenes. This was a surprising result for everybody. This was not argued. The rationale that Roberts clung to, that Sam mentioned, that this is because there's the possibility of the administration, the city granting exemptions, because that possibility exists, then this is not a generally applicable rule, is out of left field. Nobody argued that. It came from nowhere. Nobody's seen that, and he really had to twist the contract to reach that result. So something else was going on here behind the scenes that's really interesting, and I'd love to read some stories 25 years down the road about what really happened here when the clerks start writing their books.
Yeah, Andrew, so since we are sort of treating Alito's concurrence here as something that eventually might be a majority opinion, I'd like your take on his originalist argument, or his textualist argument, I guess, where he interprets the free exercise clause for us by defining all the words in it, right? Congress shall make no law prohibiting the free exercise of religion is the free exercise clause. And he does this sort of weird switch, right? Where he says, prohibiting. Well, prohibiting means, to wholly prevent or to hinder. And then he cites to a dictionary, right? And then he goes on for several paragraphs after that to talk about laws not being allowed to hinder religious exercise. Prohibiting now means hindering in Alito's mind. And he spends zero time talking about how, if Congress meant hindering, why didn't they write hindering in the free exercise?
Yeah, no, it's a very dangerous bait and switch. Congress shall make no law prohibiting the free exercise of religion, which is itself an abridgment. Right. So the full thing is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Right. And the founders and framers really looked at those as one clause. And initially, when the Supreme Court started reviewing religion and the law colliding, it looked at them as one clause, too. It's since been divided into the establishment and the free exercise clause. But shall make no law respecting an establishment of religion. And a law respecting the establishment of religion is a very broad category of laws. Anything respecting it, right? That touches most laws. But then prohibiting the free exercise thereof is a much narrower category of law, right? It says that you can hinder and dampen and do anything short of prohibiting the free exercise of religion. It says you can't prohibit. And Alito just takes that and rips it wide open by citing to, he tries to cite to a couple different dictionaries, but if you check his footnotes, it's very clear that hinder was a sort of secondary definition. Most of them make prohibit to mean what we think it means, which is you can't prohibit the free exercise of religion. So, I mean, it really is and I think it also shows sort of the emptiness of the originalist, textualist school of judicial interpretation, right? It's just they're reverse engineering the result that they want, and then claiming that it's what the framers wanted, and therefore essentially arguing from authority. I mean, it really is an empty method of judicial interpretation, statutory interpretation. If it were properly done, maybe, but it never is. Right. And Sam, I think you're right to focus on that, because I think it's going to be a big problem down the road. Yeah,
especially because hindering, the way Alito's using it, means inconveniencing in the slightest, right? And it's not. Well, and the exercise of religion, he also defines this, doesn't mean worship. It means acts, right? Yes. Acts out in the community, like.
But that's critical, because the court never examines what that means. They accept the religious believer's contention about what their religion says and means, and that blind acceptance by the court, paired with this broad interpretation, rewriting of the word prohibit, is going to be deeply problematic for us in the future.
Agreed.
I'm just reminded of my first year of law school, when one of my professors said, if you have to resort to a dictionary definition, re-examine your argument. It's probably not a good one. And also just the broad definitions here that Alito is making really cements this idea that there is like nothing that religion can't touch anymore, and really just exemplifies the privilege that they want to give them, and this ideological shift in free exercise doctrine that we've seen over the last 30 years. And it's frightening, really.
And it's all fueled by the religion in power, right? Mm-hmm. So it's almost always exemptions for Christians. Right. Alito conjures up hypotheticals where minority religious practice would be hindered, but that's not what the court actually ends up ruling in favor of. It's not the cases that the Supreme Court takes. Right. The Supreme Court bends over backwards to protect Christians.
And I mean, I think Rebecca, your point too, like this marks such a stark shift. I mean, again, remembering that Smith was written by Justice Scalia, and Alito's opinion, which we all seem to agree was probably going to be the majority, and then there was some sort of horse trading going on in the background. I mean, Alito attacks Scalia and really criticizes him, while also then citing to Scalia's opinion in the Heller case as a model of textualist interpretation, which is one of the Second Amendment cases. It really does show how far the court has shifted on this particular issue. To be attacking, to have the conservatives on the court attacking so vociferously and meanly Scalia's opinion.
So I want to go back to some of the other concurrences. Andrew was our lead for vetting appointed justices, Kavanaugh and Barrett, when they came before the Senate, Barrett most recently last summer. And you're very familiar with Barrett, Andrew, and where she's coming from. She's the newest justice. She hasn't been there for over a year yet. And I'd really be interested in hearing about what she had to say on Fulton. She wrote a separate concurrence. She didn't join, Alito or Roberts in the opinions, just in the results. So, Andrew, tell us a little bit about what she said, and did she have any points that were pretty competent and poignant?
Yeah, so I did have the displeasure of vetting Amy Coney Barrett with my team at FFRF, with Ryan Jane, one of our strategic response attorneys. We spent a lot of time digging through all of her history and writings, and it's not pretty. I don't think it's a coincidence that Kavanaugh and Barrett, the two most recent justices who were bruised very badly coming out of their confirmation hearings, are the ones that joined Roberts in this sort of more incrementalist approach to changing the law, if it can even be called that, which I know we're going to talk about in a moment. That they didn't jump fully on the bandwagon with Alito and Thomas and Gorsuch saying we need to overturn Smith, we need to rewrite the law, we need to privilege Christians fully, et cetera, et cetera. So they joined Roberts in sort of arguing a little more slowly for this. But we have to also remember that they also, in the shadow docket cases, the COVID cases, Tandon versus Newsom, for instance, they were perfectly happy to join in on that bandwagon. And essentially what Barrett says in her concurrence is, like, what are we going to replace this with? Like, if we get rid of Smith, what does our law and what does our interpretation look like? And this is not a new argument. O'Connor, Justice O'Connor famously said something along those lines before. Why would we replace something that has served us so well in the past with something that is so untested? And that is, it's a reasonable point, but it's also very clear, and you can also see this in Breyer joining Barrett and Kavanaugh's opinion, but not the first paragraph, that they want to overturn Smith. They raised a few reservations that weren't satisfied in this case, and they found Roberts's horse trading scenario opinion to get the unanimous votes more appealing in this particular instance. I mean, really, to me, this read a lot like the Masterpiece cake shop case, in that it was something of a punt. That for everybody, that's the gay wedding cake case, right? The court blessed discrimination against LGBTQ citizens by giving the Christians a get out of jail free card. So it tried to avoid answering the bigger legal questions, but it still moved us toward religious privilege. And I actually think you can say it did that a lot in this case. I don't think it's necessarily as narrow as everybody is saying. Roberts cited the Masterpiece case, the gay wedding cake case early on. Gorsuch made the same point. I think she makes a reasonable point, but I also think, to me, it kind of goes towards the overall problem with this decision, which is that it reads to me in this sort of underhanded way. Like, if you forget about the legal tests and you forget about precedent and the Smith decision and strict scrutiny and all of that for a moment, they're important, but they're also distractions. So forget about all that for a moment. The court rubber stamped discrimination against a minority in the name of God. And that really should shock every one of us, because there's no way to draw a line between that discrimination against LGBTQ citizens and any other kind of discrimination, be it race or sex. And if you doubt that, go listen to the oral arguments in this case. Go listen to the oral arguments in the Masterpiece Cake Shop case. None of the lawyers, none of the justices can come up with a reason why discrimination against LGBTQ people in the name of God is different than discrimination against Black people in the name of God, which, by the way, was a very popular argument when the Civil Rights Act was passed. To me, I think we also need to stand back for a second and recognize that 9 justices okayed this discrimination, which is it's kind of mind-blowing in a way. And to me, there is a sort of an underhanded aspect to this opinion, and that's shown through for me in Barrett's short concurrence.
And that's what's been so unsettling for me for the last few days, as I've been thinking about this case over the weekend and reading everybody's reactions to it. I really couldn't just come to terms with the fact that they did get 9 justices to agree in the result, which allows Catholic social services to participate in the program and allows them to discriminate against the LGBT community. It is a mixed bag because we, in our amicus brief before the Supreme Court, we were arguing, please don't overturn Smith. Like, that would be awful. And they didn't. And so, yay, like, there's a victory there. But it's not really a victory because, they're still allowed to discriminate. Like Andrew said, they kicked this can down the road. As we saw in Masterpiece, when they kicked that can down the road, there are more cases on the docket wending their ways up the courts. And that's not the end of that litigation. And I don't think it's necessarily the end here. I think Barrett's concurrence also just invited questions that need to be answered and cases that might answer some of these questions and give us an avenue to overrule Smith and make the standard be strict scrutiny, make the idea that the ability to discriminate, the freedom to discriminate, is more important than equality for all. But I want to throw the question back at the two of you. Those are my feelings. I think this is really a mixed bag. I think this is not the end of it. But what do you guys see as the effects of this case?
Yeah, I think there are some leaders out there who are, wiping their brow and cheering this result because of the specific result for the city of Philadelphia, where the city lost, yes, but on this technical grounds where there's this, where the commissioner has the ability to exempt someone from the non-discrimination requirement. The city can just get rid of that commissioner discretion line, and that fixes that specific law. And then probably this case happens again, right? Catholic Social Services again will say that it should be able to discriminate and still contract with the city.
Right. They can go back and rewrite the contract, and it's not necessarily over.
Yeah, but that narrow result for the city, it could have been worse, and so some people are saying, great, this result could have been worse. But in terms of its impact on the legal landscape, I think this decision's pretty bad.
Right. Yeah, I agree with that assessment. I mean, I'm worried that generally everyone is underestimating how broad the decision is, or could be, or will be once it's been litigated a little bit more. I mean, one way to read this is that the court unanimously said there is no such thing as a generally applicable law. Which again, this goes to sort of the legal nuts and bolts of the Smith decision, saying that you have to have a neutral and generally applicable law, and if it is, then it's not targeting religion, and it's probably okay. You don't get a religious exception. But if you say that even the possibility of any exception under a law makes it not generally applicable, then there's no such thing, right? I mean, the court didn't say this, but functionally it did. Which undermines the Smith decision altogether. Any law that has the possibility of an exception must meet strict scrutiny is what the court was essentially saying in the Tandon versus Newsom case, that shadow docket case about COVID. So I think we're at this very dangerous point where really any person, or if we're being honest, any Christian, can assert that a government action burdens their religion, that this is then accepted by the court without question, unless, of course, you're a prisoner in jail, then the court does tend to question it. And then if there's an exception written anywhere in government regulation for any reason, religion gets an exemption too. I mean, this is just an astounding amount of deference to Christians and none to the government.
And from a practical standpoint, Andrew, can you think of any law that doesn't have some sort of exception?
No, right? I mean, that's the way that
you...
That's exactly the way you write a law. And then you write a law that's too broad and somebody comes and says, hey, this applies to me and you didn't mean it to apply to me. And you're like, yeah, well, we'll go fix that. But I also think, and this goes to what I was trying to say about Barrett's opinion and articulate about the overall opinion of the court, right? That I think this is really underhanded the way the court do it. The court is doing something without clearly stating what it is doing. But when this shakes out later, and the parties and the Christian nationalist legal outfits are arguing this later on, we're not going to see anything about how this is a very limited opinion, that it only applies in this circumstance. It's going to be argued that any exemption anywhere in a law means that religion gets exempt. And this especially applies when you look at the nuts and bolts of what Roberts did to get to his opinion. And again, like, I'm agreeing with Gorsuch's concurrency, which just feels so weird.
And even if it isn't the biggest win for them, even if, they're still able to participate, it's a very narrow ruling, but we've already talked about there's more litigation coming down the pike. They're faced with a very friendly federal bench, and they're very emboldened by that. And FFRF has taken a lot of time and energy recently to be on the side of court reform, expanding the Supreme Court and expanding the lower courts. Andrew, can you talk a little bit about that? Like, what's the impact of this case on our court reform efforts?
Yeah, it's a really good question and really important, because I think this opinion was also a defense of the court itself. I think that's part of the reason that some of the justices we would typically not see joined why it was 9-0. There's been a lot of talk and some important bills to reform and expand the court. And historically, when that happens, the court tacks. It changes course. And that didn't really happen here, actually. It stayed on course. It simply sort of checked the reins. And I think to me, this shows more than ever why we need court reform and expansion, that the discussion of court reform and the proposals for expanding the court are scaring the justices who are going to lose power into deciding cases maybe not based on the law, which is exactly the problem in the first place. And I know some people out there are thinking, well, like, if the court, why would the court punt on this case? Why take the case? If this was going to be a punt that permits discrimination, why get involved in the first place? There's no mandatory right to appeal to the Supreme Court. So why would you do this? And Rebecca, you kind of touched on this at the beginning. This case was taken before the 2020 election, and it was actually argued right around Election Day. So you have at least 4 justices who wanted to accept it when Ruth Bader Ginsburg was still on the court. Before the talk of court reform exploded after McConnell stole another seat on the Supreme Court. So I actually think that the talk and the proposals for court reform influenced the court on this case. And to me, that is all the more reason to keep up the talk and keep up the pressure. So, just kind of put it one other way, like, the decision was meant to release the pressure and check that momentum for court reform. Maybe until after the midterms, who knows? So I think the message that we should take away is precisely the opposite, that court reform is needed now more than ever, because the court is playing politics with our constitutional rights.
Well, and also with Mitch McConnell's recent pronouncement that if Breyer were to retire or something was going to happen, he would not allow Biden to nominate and give that person a hearing. So we're back to that again. Yeah. So we have a lot of questions, and I think we can move to that portion of the show. So Angela Abrams comments, as a member of said community, I take it as a given that I'm going to be discriminated against without there being any logical reason for it. And I think that is a reasonable takeaway, given this current court.
Yeah. Sorry that's your reality.
The frustrating thing, right, is that it's different for you to go into a Catholic church on the weekend and them to deny you communion or refuse to bless your marriage. But here we're talking about the Catholic Church hijacking the machinery of the state to impose its religion on other people. And this is what we wrote about in the FFRF amicus brief when we were briefing this to the Supreme Court, right? This is the Catholic Church demanding a right to contract with the city and then use that power and that imprimatur to then essentially impose its theology on other people, using the power and the stamp of the state. And that is one of the big problems in this case that we were deeply worried about, in which the court rubber stamped here.
And Yes, and that's the reality, and that's what's frustrating about this decision, because there is a piece in the Alitos Opinion where he wrote, like, they don't seek to impose their religious beliefs on anybody. They just are seeking an accommodation for their own religion, and that's just really ridiculous. We all know what they're doing. So Ann Ben-Dixon asks, what can we do to stop this court-based discrimination against the non-religious? Expand, unpack the Supreme Court, appoint more justices in the other courts, donate to FFRF?
Yeah, certainly donate to FFRF. That's crucial. I mean, the fight that we have right now is, I mean, Rebecca, Sam, and I have been doing this for a long time, and it is more of an uphill battle now than ever before. So if you can afford to support that work, please go to the FFRF website, ffrf.org, and please do that. We absolutely also need to expand the Supreme Court. This is something that FFRF has been saying loudly for a long time. We're starting to see other groups join in on that call. We really need to not just expand the Supreme Court, but the entire federal judiciary. And I would really encourage everybody to check out our report on the Christian nationalist judges and how they have been packed in to the federal court system that in December, right? The courts are already packed. The courts are already gone. So any talk of court packing is beside the point because the courts are packed. Now we have to talk about how to fix them and how to reform them.
Right. So this is a really good comment that we got via email, or question that we got via email. Do these religious groups passing themselves off as foster care agencies receive any federal funding? It's something that we did not discuss when we were discussing this opinion. So do they receive federal funding?
I don't know the specific answer to this. I mean, certainly the Catholic Church receives a bunch of tax benefits in the form of not being taxed. But there are a lot of other scenarios where we do know that religious organizations are receiving federal contracts and federal money to perform duties, and they're also seeking a license to discriminate while performing those functions. It's something that FFRF is involved in a lawsuit over, where President Trump passed just signed a regulation allowing for discrimination by federally funded private groups doing social service work to discriminate. And the Biden administration has been slow to address that and to revert the rule to its former stance, where if you're receiving federal funds, you need to remain neutral. But now the Biden administration has announced that it's at least looking into revising that. So while we are involved in an ongoing case challenging that, we are sort of awaiting to see what the Biden administration is going to do.
Yeah, I'll just add to that a little bit, because I think Sam was really focused on the federal aspect of that question. But I think it's important to note that the Catholic Church here Catholic Social Services does get taxpayer funds as part of this contract, right? They're not doing these services of vetting these groups for free. They are being paid, I think, do not quote me on this, but I think it was upwards of $20 million for all of the different services they were providing under the various contracts over the years. So they are receiving taxpayer funds. I don't know what the breakdown of that was, federal versus state versus city or anything like that. But they are contracting with the government, and the government is then turning around and paying them.
Yeah, they're getting government funds and are allowed to discriminate with those funds. It's very unfortunate. The next question, what advice would you give the city of Philadelphia? Advise them not to renew the contract next year?
I mean,
it's hard.
Yeah, from a policy standpoint, obviously the city wants to ensure that all same-sex couples can freely adopt without enduring discrimination. And I think that that takes precedent over avoiding future litigation on this. So, I mean, I would advise the city, Yeah, if you cut that sort of discretionary exemption from their non-discrimination rule, just cut that from the law, and then if Catholic Social Services continues to discriminate, which it will, then you cannot renew that contract.
Yeah, I mean, one other option too that I've been thinking about a lot lately is that, you know, the government is not required to contract with private religious groups or any private group to provide these services. It's chosen to do that, and it's chosen to spend its taxpayer funds in that manner. The city would be within its rights to say, no, we're not going to do that. We are going to go ahead and provide these services and this vetting and take care of all of this on our own. We're going to spend the $20 million, whatever it was, on staffing and doing this all on our own, rather than outsourcing it to groups that are going to discriminate. And that is perfectly within the rights of the government to do. I mean, if you read Alito's opinion, he spends a lot of time going over the history of foster care and orphanages and how much religion has played a role in that, as though that gives religion a right to continue to do that in perpetuity, which is not the case, right? Like, religion also used to regulate speech and other religions and used to be the sole criminal law. And slowly secular governments have taken over those roles, and it doesn't give religion a right to still enforce any of that. It's perfectly acceptable for the government to take over those roles and squeeze religion out. And if I were advising the city, that is what I would tell them to do here. I would say, you know what, you gotta stop. You could absorb a lot of these yourself. You can hire more people and reassign your budget to make it internal. That's what I would do.
And that's what a lot of different cities and states are going to have to do with the Supreme Court ruling the way it is on religious freedom issues.
Yeah, it does bring up a question, because I think you could read this decision. They didn't address it squarely. I think you could read this decision to, at least you could make the argument, and the other side will, if, for instance, Philadelphia does this, that the churches have a right to contract with the city to provide these services. I mean, there was sort of this implicit recognition of that in Roberts's opinion, which I don't think anybody would well. Anyway, that's going to be, if that happens, that's going to be a fight in the future, I'll say.
Yeah, it's wild because really the correct interpretation of what Catholic Social Services is trying to do here in terms of exercising religion is it's saying contracting with the city is an exercise of its religion, right?
Yes.
Like, that's the part that the Supreme Court doesn't grapple with and sort of glosses over, like, oh, sure, because Catholic Social Services has taken care of foster kids in the past, like, that's probably what the religious freedom issue is here. But that's not what the city of Philadelphia is concerned with. They're concerned with contracts, and that's what they're regulating.
And that's what we were kind of trying to talk about when we were saying that this is the dangerous territory, where the courts are just accepting the professions of religion as though they are true without ever bothering to examine them, and how deeply dangerous that kind of deference is. Apologies for all that alliteration. It was unintentional.
So one last question, again by Ann Bendixson. Do you believe the more liberal justices will continue to side with religion? It's a great question, and something that we've been concerned about. I know that Justice Kagan has been one of those who has really kind of been surprising on a lot of these cases over the last few years. I think when I mapped it out and wrote down all of the religious liberty cases since she's been on the bench, she's really 50-50 on the outcome. So what do you guys think?
I think that the loss of Ruth Bader Ginsburg here is felt incredibly acutely. I think she was the greatest check on the liberal justices in terms of how they viewed these issues. And I think we're going to see a lot more 7-2, 8-1, or 9-0 decisions warping free exercise in this way, precisely because that check is no longer there. Yeah, I mean, I think I agree with that. I think this is
This is one of the strange aspects of this particular opinion that we were kind of trying to wrap our minds around earlier in the show, is there was something going on behind the scenes here to bring Sotomayor over into this case, that to bring Sotomayor onto Roberts's opinion, that made it more attractive, which Alito's exhausting opinion, 77 pages, 80 plus footnotes, is like a shining beacon of maybe what that was. So I think this is a little bit of an outlier in the sense of how the justices lined up. We have seen Sotomayor write some brilliant and spot on dissents in the last few years when it comes to these cases, either Establishment Clause or the Free Exercise Clause cases. And as Sam pointed out, she was often either joining or joined by RBG, who's unfortunately no longer on the court. I don't think Sotomayor has any problem with being the lone voice, or as Linda Greenhouse put it the other day in the New York Times, the truth teller of the Supreme Court, which suggests to me that there was something going on behind the scenes here with this case that we'll know about at some point, but maybe not yet.
Yeah, and actually, Andrew was on vacation last week when this decision came down, and I texted him and said, it's 9-0, and the first thing he wrote back was, Sotomayor, ? Like, wait, where was she? So yeah, there was probably something going on, and hopefully, I think that she'll be back once, as we said, this can was kicked down the road. There's going to be more litigation. Once that case comes up before the court again, I think we're going to see one of those wonderfully strong, stinging dissents from her. So that's it for this week's Ask an Atheist. Thank you for tuning in, and please check out Free Thought Radio this week when Dan Barker and Annie Laurie Gaylor speak to FFRF's Anne Nicole Gaylor reproductive rights intern Barbara Alvarez on the increasing threats to abortion rights in state legislatures all around the United States. To find out where to hear Free Thought Radio, go to ffrf.us/radio.